So we're live on Facebook now. This is presentation notes on misrepresentation. First thing first is, what is a misrepresentation? Well, that's what it is, a representation of a fact or facts which are untrue, made by one party to another before a contract is made, and that representation induces or compels the other party to enter into the contract, and that is effectively what misrepresentation is. So what is a fact? What is opinion? Well, that depends on the person's knowledge. There's two cases, quite old. Case of Bissett and Wilkinson, 1927, where the seller of land, he was selling farmland which had never been used before to graze sheep, and the seller said it takes about 2,000 sheep on the field, but that was false. But as the land had not been used before, that was only an opinion. There's also the case of Smith and Land and House Property Corporation, 1884, where the tenant of a landlord of a hotel described one of his tenants as most desirable when he was selling the hotel, when he knew that the tenant was in arrears and on the verge of bankruptcy. So that was clearly a fact within his knowledge. Can silence be a fact? Can it be a misrepresentation? Well, it can be in those three circumstances. First of all, the change of circumstances. There's a case of With and O'Flanagan. That was a case where the seller gave a fact which was true at the time, but before the contract was actually made, the facts had changed. The fact was given that the business took £2,000 per year, but then later on the seller became ill and the customers went elsewhere, so he wasn't no longer taking £2,000 a year, and therefore the business at the time of the sale was worthless. The court held that where the statement is rendered false by a change of circumstances, there is a duty to disclose, and a failure to do so will result in a claim for misrepresentation. The next case, Nottingham Paint, Brick and Tile Company against Butler. The solicitor was asked, is there any restrictions on the land? The solicitor said he doesn't know, but what he didn't say, he said he hadn't bothered to check. The fact was, he didn't know because he hadn't bothered to check. That was a half-truth. He should have said, I don't know because I've not checked, and if he had said that, he wouldn't have been sued. But because he didn't say, I haven't checked, he was sued, and sued successfully. So, moral of that story, if you're asked a question and you give an answer, make sure you know it's true, or make sure you check your facts. The last case, Dimmick and Hallett. The landlord was selling his farmland with tenants in situ. He told the buyers that the farms were let to the tenants, but what he didn't say was that the tenants were about to leave, and that was also held to be a misrepresentation. There's also cases of insurance, insurance contracts if you're silent. There's also some cases of sales of land, offers of shares. You need to disclose facts in those sort of cases where there's some good faith that must be offered. So there's three types of misrepresentation. There's fraudulent, there's negligent, and there's innocent. Probably negligence is the most common form of misrepresentation because it's the probably easiest one to prove, and if you are bringing claims for misrepresentation, you need to establish which type it is, and if you're going for the fraudulent one, plead in the alternative, because what you don't want to do is restrict the claim if you bring in fraudulent misrepresentation to just that. You need to say it is fraudulent, but if it's not, it's negligent. If it's not, it's innocent. So the types, fraudulent misrepresentation, essentially it is what it says on the tin, it's fraud. There's a case of Derry and Peak, and the statement of fact must be made knowingly, it must be made, knowingly or without belief in its truth. It's essentially a lie, or recklessly or carelessly, whether it is true or false. And it's for the claimant to prove that it was fraudulent. In that case, or at least that's what I gather from the cases. Negligent, slightly lower test. The statement made was believed to be true, but there's no reasonable grounds for that belief. So if I say my dogs are super healthy, I'm saying they're super healthy because I've got them checked, and that's potentially negligent misrepresentation. And there's two types of negligent misrepresentation. There's the common law misrepresentation found in the case of Headley Byrne and Heller and Partners, whereby a special relationship exists, like a soliciting client or bank and customer, and in that case a statement must be careless and it must be reasonably relied upon, but there doesn't have to be a contract between the parties. So between a bank and customer, in this case there was no contract, and the claimant relied upon the bank's representation in that contract. And if common law negligent misrepresentation is to be relied upon, then it's for the claimant to prove the claim. The other alternative is to rely upon Section 2(1) Misrepresentation Act 1967, and again that's a statement made without reasonable grounds for belief in its truth. But in that case there must be a contract, i.e. seller and buyer, and in that case the burden is on the defendant to prove that they had reasonable grounds for believing the statement to be true. And so if you're pleading any misrepresentation on the basis of a contract, it's probably best to rely on the statute rather than common law. In the common law, by the way, there's no contract required. Innocent misrepresentation is basically the lowest standard of misrepresentation. It's a statement made in the belief it's true and with reasonable grounds for that belief. Not much to say on that, as you can see by the slide. Like I said at the start, the claimant must have been induced into the contract, so there must be some reliance. The claimant must show that they relied on the statement, and there's 3 cases. The case of Redgrave and Hurd, where the seller told the buyer that the value of the business was £300, it was fact worth £200, and the buyer relied on that statement to enter into the contract, and the court found he was entitled to rely on it. Atwood and Small, where the seller made exaggerated statements, and in that case the buyers didn't rely on those statements, they actually got those statements checked by a surveyor, and so the court held that the buyers did not rely on the statements because they had checked the facts themselves. And the case of Webster Liddington, most recently, that's a slightly different case because it involves third-party facts. So in that case the doctor relied upon a leaflet provided by a manufacturer of the product that they were using. The doctor did not issue a disclaimer to say the information was not his, and so he was held to have adopted the information, and because he adopted the information as his own, he was held to be giving misrepresentation of facts. If he had said this information is not mine, then he would have been fine. So the effect of misrepresentation, it makes a contract voidable, not void. There is a difference between the two. Voidable contract means the innocent party has a choice. They can either carry on with the contract i.e. affirm the contract or rescind it. If you want to affirm a contract, say you bought a car on the basis that it had a really good service, there's nothing wrong with it, there's one owner or something like that, and you go and drive it and there's something wrong with it, if you don't do anything about it and carry on driving it, you might have affirmed the contract. So if there's something wrong with it, go back straight away to return it. Rescission is not available if the contract is affirmed or there's a delay, and delay isn't, is objective really, depends on all the circumstances, or if the parties cannot be restored to their original position. Rescission is not available if the third party acquires rights under the contract, like say assignment, or if the court decides under the legislation to award damages in essence instead of rescission, and that's a discretionary measure. So the remedies for each type of misrepresentation: fraudulent, you're entitled to rescission and damages. Rescission essentially means putting the parties back into the same position. The contract is cancelled. Negligent misrepresentation, there's a discretionary remedy of rescission, but you are entitled to damages. And if it's innocent misrepresentation, then the court has discretion on both rescission and damages, and so you might end up with nothing if a claimant claims innocent misrepresentation. Types of damage: fraudulent, the claimant can actually recover the actual damage caused. The damages doesn't have to be foreseeable, there just simply has to be a causal link between the damages and the misrepresentation. So essentially whatever costs have been incurred, whatever damage has been incurred, it is recoverable if you can show a link. In the case of common law negligent misrepresentation, only losses reasonably foreseeable as a consequence can be recovered. The statutory negligent misrepresentation, all damages flowing from the misrepresentation can be recovered. And innocent misrepresentation, essentially the loss is reasonably foreseeable, obviously at the discretion of the court. And that's it. Any questions? For the benefit of the live viewers, any more information you can visit our website, send us an email, make appointments online, or visit us on Facebook and Twitter, and we do have videos on YouTube as well. Thanks.